Please give us a brief introduction.
Yes, sir. My name is Jigyasa Panda. My roll number for OJ's examination is 500125. I have completed my BLLB from Institute of Law, Nirma University, and I have completed from my LLM from Gujarat National Law University with Constitutional Law as my specialization.
Okay, tell us something about your hobbies and your achievements.
So in hobbies, I like to paint, sometimes sketch, and I have recently developed a hobby of reading books and going to art museums. And so in achievements, I have in my school days, I have gone to Tritiyo Sopan in Scout and Guides, and I have also been in debates and dance competitions in regional level.
So, how many years you have stayed in Gujarat? Over 7 years,
Yes, so
five,
6 years.
6 years, right? Okay. Um, okay. So, and now you are still in Gujarat or you are
No,
back in
sir, I'm
Odisha?
in Odisha, Sambalpur, sir.
You are in Odisha, right? Okay. So, what are the major changes that you find, in the generally speaking, in the lifestyle there in Gujarat and in Odisha as a, as a citizen in that sense, and secondly, as a student of law, the
Yes.
law ecosystem in Gujarat and the law ecosystem in Odisha.
Yes. So as a student over there in Gujarat, so because I have not been a college student in Odisha, in Gujarat, I can particularly say I don't know if it's a point of differentiation, but something to be noted that in Gujarat, it is very safe and convenient for students to travel and also to participate in competitions and just be move around and from college to college to interact with students. It was more convenient, I would say, and also a little bit convenient in a way for girls also. I don't know if it is a problem in Odisha. I particularly am not aware of that. In terms of a student, I would say that especially like in both of my colleges, I have gotten good amount of exposure in terms of academics, and I have had really great professors and teachers to guide me throughout my journey in the college.
Okay, so you have also completed your post graduation, and have you qualified UGC NET and all?
No, sir, I haven't
Not
qualified.
qualified. Okay, so yes, ma'am.
Okay, Jijnasa, this is your first attempt?
No, ma'am, this is my second.
Okay. Now, if God forbid for any reason you are not able to crack this time, what are your future plans?
Ma'am, I would definitely try to attend a few more times, but at the same time, I won't take it as a failure as such, because this process has taught me an immense amount of self-discipline and a lot of hard work that has gone into it, and I have gained a lot of knowledge from it. So, in either way, it is a win for me. I would not see it as a failure.
Okay, any special reasons can you specify why you are joining OJS? And as a woman, what are the significant changes as a woman judge you can bring to the society?
Ma'am, I think representation is one of the key features that is required in all the spheres of public services and even in private services. Representation is the key, and as many representation from different strata is possible should be there. So, as a woman, I think that I would bring in a perspective of a woman, and I think this unique perspective might help me in dealing with certain situations in certain cases where I might be able to balance the situation in a more positive way, is what I feel personally. And yes, ma'am.
Okay. Now, can you tell me something about judicial activism? What it is all about?
Yes, ma'am. So judicial activism is when the courts, our Supreme Court and High Court, are given the power of judicial review, which is to keep a check and balance on the legislative and executive actions, and to review the validity, constitutional validity of the same. So judicial activism is when, to meet the ends of justice, certain in certain situations, certain guidelines are prescribed or certain directions are prescribed. For example, in Vishakha versus State of Rajasthan, it was a case of judicial activism where there was no legislation at the time present for that situation. So the Supreme Court provided guidelines for the to tackle with the condition. So that would be judicial activism.
Okay. Um, so today itself, um, or rather yesterday, the government has brought in a second draft of the three important bills they wanted to amend.
Yes.
In short, can you tell me what are the major changes they have brought about in all these three bills?
So I am aware of the objectives of the bills that were to have speedy justice and fair trial and victim oriented system. I have not personally gone through the bills as of yet. I would definitely go back and read. But I am aware of the changes, the stay on the change on the sedition uh, case regarding this bill, because this bill proposed to introduce certain changes to the sedition law, and the case that was pending in the Supreme Court is now stayed on that regard.
Okay, that is a more generalistic, approach.
Yes.
What you do is, yesterday, Bar and Bench has published a very good, open article on this. That
Yes.
what exactly they have changed from the earlier first draft to
Yes.
this second draft. Okay,
Yes.
in very, like in 5 minutes, you can finish that article, and it has given 5 to 6 points of difference of each of the bills.
Yes.
So, as a student of law, just note it down. Okay,
Yes, sir.
those. Okay, now let us come to more theoretical aspects. Um, which is your favorite, paper among all these papers which you are given in OJS?
Sir, I would say constitutional law should be my favorite. It's my specialization also, so I like the subject.
Oh, very good. Constitution and jurisprudence, right? Good. Most of people they eliminate that paper while taking. So that was one of your optionals, jurisprudence and constitution.
Yes.
Okay, good, good. So then let us start with part three first. Okay, according to you, and give me at least two, three good reasons why you feel so. Which is the most important article, okay, of part three?
Sir, can there be more than one?
Most important means one.
Okay.
Most important.
So most important, I would go with constitutional remedies, Article 32, because without that, I feel like all the other articles would not be as much as effective without Article 32. Article 32 is that article which makes all the other articles operative, and in their truest sense, they tend to come to effect. Which is constitutional remedies, the power of the Supreme Court to provide a writ petitions to and there are five kinds of writ under it, and all the five kinds of writ go on to make effect of the fundamental rights that are provided under part 3. So
Okay, suppose I'm a private individual, nothing to do with the government, right? I'm not in any public office.
yes.
So suppose the Supreme Court wants to issue a writ, okay, for me, a private person. Out of these five writs, which writ it can issue?
Sir, you were a private person, and sir, I just couldn't understand the question very well.
Most of the writs, okay, can be issued against public authorities,
Right, sir.
right?
Yes, sir.
Quasi judicial authorities, right?
Yes. Yes, sir.
But which writ can be issued to private individuals, just citizens, need not be public authorities.
So habeas corpus can be issued.
Yes, habeas corpus. Okay, so tell me what is the difference between your certiorari and prohibition, since the main objective of both the two writs seems to be the same.
Yes. So both are applied on court, the decisions of the court. One is certiorari, uh, which is applied after the judgment is pronounced, and to put a stay on the judgment if it is violative of any of the fundamental rights. And prohibition is when the judgment is delivered, before the judgment is delivered, to prohibit or to make sure that the fundamental rights are not infringed further in the case.
Okay. Supreme Court has given an observation, not recently, it's a very famous observation, that where Article 31C comes in, Article 14 goes out.
Yes.
Have you heard that?
I don't remember the case name, sir, but I remember the this observation.
Yeah,
It's very
yeah.
famous.
Just tell us the context. Case name is not required. Just the context. Why? Why Article 31C can override Article 14?
So 31C, in 31C deals with the provision that Article 14 and 19 could be overlooked if the directive principles of state policies are being applied on certain situations. So, sir, this was to the objective was to give primacy to directive principles of state policy over the fundamental rights. And sir, this after the observation in Minerva Mills case and after the amendment of 44th Amendment, the directive principles of state policy and the fundamental rights are going hand in hand. There is a harmonious construction in between those parts, and they are not clashing as such because one is complementing the other. So Article 31C necessarily is not, I mean, it was to give primacy to the directive principles, but the situation is not as such now.
Okay, it basically in Article 31C, uh, two initially, okay, two um, directive principles were mentioned. Can you do you remember?
No, sir, I can't remember.
39B and C. Hmm,
Okay.
okay, that is fine. Um, then coming to our uh, the Constitution, okay, does not allow in India. Constitution does not allow class legislation.
Yes.
So, can you tell me what is this class legislation, and if you can give example uh, within India or outside India where it was prevalent?
So, class legislation is where the differentiation is created for a particular class, and there is no rational nexus to go or to achieve an objective. So, the differentiation created is basically discrimination, which is not allowed under Article 15 of our Constitution, and as well as Article 14 of our Constitution. So, class legislation, but if a person represents a particular strata of a community, then in that case, to reach an objective, if there is a rational nexus, then class legislation, that class can be given a particular benefit per se to achieve an objective. So
Okay. Um, can you tell me before the collegium system was brought in place for the um, appointment of judges to Supreme Court and High Court, what
yes.
was the system which was followed? Number one. And secondly, tell us something about the collegium system. Okay, the three judges case, the NJSC case, current situation, and at last, give you opinion. What do you think? About the collegium system, and if you think that any changes, are required, then what would be those changes?
So, firstly, collegium system was introduced in Before that, there was primacy of the executive. After collegium system in Supreme Court on record versus Union of India, that is the second judge's case, that is where the collegium system came to place. And in the third judge's case, in referential, in that case, the collegium system became a body with the concrete, a body where the collegium system was particularly followed uh, with the opinion of the Chief Justice, Honorable Chief Justice of India, and as well as the Honorable President of India. So before that, executive supremacy was recognized in SP Gupta versus Union of India. The word concurrence was interpreted, and it was said that concurrence is not consultation does not mean concurrence. That is to say that executive supremacy would be prevalent. After that, the second case, the Supreme Court on record case, went on to interpret the word again, and it interpreted in a way that both the Honorable Chief Justice and Honorable President, both of their opinions should be taken into consideration, and there should be a collegium system with the Honorable Chief Justice with two of the senior most judges of the Supreme Court would make a list of the recommended name of the honorable judges, and accordingly honorable president would give his opinion on it. The third judge's case gave us the collegium system that we know right now as it works, is honorable chief justice with four senior most judges of the Supreme Court along with the opinion of the honorable president. So after after this system, NJAC was introduced. NJAC system where both the executive members as well as the members of the Supreme Court and Supreme Court were both part of the NJAC. They were members of the NJAC. However, this system was very similar to the system that is present in US. It is a very similar situation, and so because to prevent any political influence on the appointment of judges, NJAC was held unconstitutional in the fourth judge's case, which is Supreme Court on record case number 2 in 2015. So, in my opinion, collegium system works. In my opinion, sir, it works really well with the options that we have right now. It works really well because it ensures that the judiciary is independent of any of the influences outside of judiciary. So, in my opinion, sir, the options that we have, collegium is the best working one. I mean, there is always a room for improvement, but the system works for now, sir. It works.
Okay. So tell me something about the concept of plea bargaining. What are the advantages and disadvantages of plea bargaining? And after we have introduced it in our criminal justice system, um, has it given any benefit to us?
So, plea bargaining is essentially a concept which was taken from the American jurisprudence. It was introduced based on the Mullimat Committee report, and it is also it came to with a particular with a very structural system in place, and it also worked initially for towards the reformative justice that the Indian legal system aims for. However, the plea bargaining with the objective with which it was introduced is not being fulfilled right now, because not a lot of number of people are opting for the system of plea bargaining, and they're going for trial. Maybe because the end result of plea bargaining is conviction and not acquittal, and people and due to social stigma, or maybe due to any other reason, they would not want to confess to any offense, and maybe because of that there is less number of people going towards plea bargaining. And also because it works in US because the conviction rate is also more in US as compared to India. So maybe that is also one of the reasons why plea bargaining didn't work in India.
Mhm.
Okay, Jijnasa, can you tell me that, do you, what is your opinion regarding the introduction of local languages in the courts? especially in Odisha, when we have a diverse aspects, different accent of Odia language is being spoken in different districts of Odisha. How will it be beneficial for introduction of the local languages in the course?
Yes, ma'am. Well, local languages, in my opinion, and also the recently where the Honorable Chief Justice he has introduced judgments in local languages also to be provided to people. So local language is very important to be used in legal system so that it is more relatable to people, the common man, because people who are actually studying law in English, they can speak in English in court, and the affairs of court there is a gap between what is happening in the court and people outside the court. They are unable to understand what is going on in the court, and that makes them either fear the system that is in place, or they lose faith in it. So by introducing a local languages in court, I think it would enhance the faith in judiciary. And also it is also convenient because all the judicial officers that are being appointed are let's say in Odisha, all of us, all the applicants are tested on the efficiency in the language. So essentially all of the applicants and all of the people who are becoming judges and judicial officers are fluent in the language. So there is no reason to keep local language outside of the court. So ma'am, I feel it is a very positive thing to introduce.
Okay, can you tell me that if a case comes to your court where there is a there is a traditional customs or culture being followed in a particular area, and law, one side is the traditional culture or the customs, and on the other side there is the law. So as a judge, how will you decide what are the things you will consider before giving your verdict when a case involves both of these?
Yes, ma'am. So, ma'am, after becoming a judge, in my opinion, the main important job that a judge has is balancing of all the rights and duties of people involved in a case or the society. So, if a custom or a tradition is involved along with a law, as ma'am, first of all, we have to see that if the custom is involving any question of infringement of any fundamental right as such. If there is an infringement of fundamental rights, ma'am, there it is, then the custom cannot prevail over the law. However, we also have to see that the sentiments of the local people, if involved in a particular situation, then we have to take care of that as well, and we have to consider that as well. We cannot ignore it, because a law comes from the society, and that has to be considered. Having said that, if article 25 to 28 are involved, and there is a tussle between article 13 and article 25 to 28, then accordingly the judgment has to be given keeping in mind the facts and circumstances of the case. In, for example, in Anand Marg case, where the Tandav Nritya was in question, and the judgment was given that it is not an essential practice of the particular community, and it is going against the public order and morality. So accordingly the facts have to be scrutinized.
Okay, can you tell me about the introduction of artificial intelligence, the chat GPT, which is now in the scenario? How does it affect your judicial system?
Introduction of AI, it is an advancement in technology, and advancement in technology is always better in all the spheres of jobs. So, in if AI chat GPT, it would enhance, I would say, the research that is being conducted for the judgments, and from the research point of view, more and more convenient research can be done in chat GPT, which takes a lot of man hours in general when we conduct general research. But when we use special tools to conduct research, then it becomes very efficient and very quick to reach to read a lot of judgments very quickly and to know what is the essence of any particular article or anything as such. So it is a positive thing.
Okay, right. So, some questions on IPC. Let's say, um, can you differentiate between abduction and kidnapping?
Yes, sir. So abduction doesn't have an age bar or a gender bar. Kidnapping has two categories under it: kidnapping from lawful guardianship and kidnapping from India. Under lawful guardianship, there is an age bar of 18 years for women and 16 years for men. And also the words used under kidnapping is taking and enticing, which indicates either physical force or deceiving a person to be taken away, or from of a minor or an unsound person. But under abduction has to be coupled with a particular offense to be made criminally liable, and the words used are deceiving or by force. So the age of the person and the consent given by the person makes a difference between kidnapping and abduction.
Okay. What are the ingredients of AFREC?
Sir, under AFRE, there are minimum of two people required to commit the offense. It has to be committed in a public place and violating the public order, creating a nuisance essentially under Section 159.
Okay. Differentiate between, since you have taken jurisprudence, natural justice, or you can natural rights,
Yes,
okay, fundamental rights,
yes,
and human rights.
yes,
Okay, and you give me one example, okay, where a right is a natural right, okay, but may not be a fundamental right with respect to our constitution.
yes, sir. So, natural rights comes from the natural school of thought, which is that the law comes from the subconscious within, which means that every human being is aware of the conscious choices that they are making, and it should be moral in nature. And even if and it has no relation with the society or the state that is in power. It comes from within the human being, and he is aware of what he is doing. So the right and the wrong comes from within. So a human right is something that is by the fact that a person is human, has the basic he has the basic right to have the human rights. Fundamental rights are those rights which came to operation under the Indian context, to operation after the commencement of the constitution and not before that. However, fundamental rights are deeply motivated from human rights under UDHR, which came just slightly a few years before our constitution came to force. So they are very highly motivated, and there are very similarities between human rights and fundamental rights. But all the human rights are not fundamental rights per se. Or fundamental rights are only those rights which are enlisted under Part 3 of the constitution.
One example of a right which is a natural right but not a fundamental right.
Um, So right now, I maybe right to marry would not is not a fundamental right, but it is a human right.
Okay. Okay, since you have taken up right to marry, what is your opinion regarding the legalization of marriages between the LGBTQIA plus community? It seems that the apex court wants that, but the government is not. What it seems is that government maximum, what they are saying is that maximum we can do is that we will, what they want to do in private, we will not get into it, but we cannot legalize or institutionalize it. What is your opinion?
So, the landmark judgment that is recently passed in Supriya Chakravarti versus Union of India deals with this particular issue. It was a five-judge bench, and so in that, the judgment that was given was that right to marry is not a fundamental right, and it cannot be recognized as such. And also, the bench mentioned that judiciary is not the right forum to make these changes. Legislature is where the changes can happen, and they can proceed uh, those particular laws. So in my opinion, this legalization would have been a positive step towards what happened in decriminalization of 377 section 377 that we saw in Navdeep Singh Johar case, and the arguments that were being placed in front of the honorable Supreme Court were very valid arguments that even after decriminalization of section 377 there are certain discrimination happening, and all the rights are not available to the queer community. All the rights are not available, like health insurance and health insurance. There are bundle of rights of marriage and being spouse of each other, which gives pension rights, and there are a lot of bundle of rights that are not right now available to queer community couples. So in my opinion, that would have been a positive step towards decriminalization of the homosexuality. However, the observation that has been made by the honorable Supreme Court is also valid, that there are a lot of legislations which have to be changed, and the Supreme Court is not a body which changes legislations. It only adjudicates upon judicial problems. So if legislature brings out any these big changes, then that would definitely be sir appreciated.
Okay, fine. So that would be the end of the interview. Now the feedback.
Thank you.
So from my side, um, uh, eye contact, just you practice that in the with the mirror, in the mirror interview. Content, style of presentation, flow of speech, etc. is very good from my side. So my only thing is that since it is a virtual interview, you just take care that in the actual interview you ensure eye to eye contact, 80 to 90% time with the person who has asked the question, and rest 10% with the other two or three board members. Okay. Rest, everything is fine. I'll be giving you around 85 out of 100. Okay. Well,
Yes, you can say that's the same thing that I also want, that your content, your flow, speech, everything is well balanced, and you are delivering the answers in a proper way also. So there is nothing to change in that context. But as this is a virtual interview, we cannot see your eyes, movement of your eyes properly. So it's up to you that you just practice the mirror interview, so that can be met out if it is exist. And if out of 100 I have to give you, I will also give you 85 out of 100.
And if I could ask a question.
Just
just a minute. Yeah, see, your major advantage is that you are strong in constitution. That is your special paper, because most of the candidates we interview, they they're not strong in constitution. So that would be a big advantage. Okay.
Okay.
Okay. Just a minute.
So, what is the maximum that I could have achieved? I mean, what is the room for improvement? Like, how much can I improve in order to do a lot better than this, what I have done?
No, I don't think you will be able to do a lot better than this, because I think you are already at the apex, top 5 percentile of the whatever 40, 50 interviews that we have done till now.
Okay.
Within top 5 percentile, you would be there. That eye contact thing is the only thing, because that I am not able to judge here. Okay,
Yes.
rest,
the board posture,
uh,
everything is
it
perfect.
is fine. And I think one place you are unable to give the answer, you clearly said that I am currently I'm on. So no guessing, no bluffing. If you do not know, just tell them that
Yes.
you don't know. Okay.
Okay. Yes.
Rest your your the way you approached it is I was very satisfied with that.
Okay, sir. Okay. Thank you so much, sir. Thank you for the feedback. Thank you for the time. Thank
Thank
you,
you.
sir.